Hello, hello. All right, we're on. Everything good, Justice? All right. Well, thank you everyone for being here. My name is Jack Archer. I'm the policy director for Spokane Community Against Racism. Um, I really appreciate those of you who decided that you want to be here as opposed to other governors today. We weren't quite planning on trying to compete with that. We're really grateful for everyone's time. We're especially grateful for the time of Judge Fennessy and Mr. VanWinkle, who have both put themselves forward to be Spokane Superior Court judges for position 11. I want to, can we just real quick get the home screen off from behind me? Do we know what's going on there? Oh, it's like this there. Yeah, we're not using that. Let's just shut that guy down, I guess. That is interesting. All right, well, we're working on that. Now that's, as we do that, I just want to again extend my welcome, give folks a sense of what we're going to do. Right now we have people, thank you so much. Right now we have people here in person. We also have people joining online and hope to have some participation and people involved in asking questions. SCAR want to do this event because a lot of people do not know what to do with the judge portion of their ballot. And for a long time, I was one of those people, and it's only by the benefit of very specific access that I now feel more confident filling out that portion of my ballot. But most people, very reasonably, don't even necessarily understand all the various courts and how they function. And so tonight is an opportunity to not just meet two candidates, but to hear about the court and to hear about these systems and to get a better understanding of how they each hope to impact those systems. We're going to start out the night with some standard questions. Both of the gentlemen here tonight were provided those questions 48 hours in advance, so they could check them out, prepare their answers and whatnot. They're standard. We'll go through those on a hopefully decent time clip. And there will not be any back and forth. I want to clarify, this is a forum, not a debate. So we're going to give each gentleman the time to give their answer, articulate their positions, and we'll leave it to the lovely audience and the voters to decide what they make of those. After that, there will be an opportunity for audience questions. I'm going to pass around some of these index cards, and if anyone wants to submit questions via Zoom, they'll be able to do that as well. Some quick ground rules for that I'll reiterate later. Is that please we ask you please limit your questions to things that relate to Spokane courts. We're not talking about Supreme Court decisions. We're not talking about big partisan policy issues. We are here to learn about Spokane Superior Court, and that's what we want to keep the questions around. If I get questions either in the chat or on the index cards that don't seem to be within the scope of the event, we're reserving the discretion to leave them unasked for now. But of course, both these gentlemen have made themselves available, and you can always ask them to their faces, should you so choose. After that, there'll be some, there'll also be a bit of closing where both of our candidates will get to say a little bit more about themselves than they would have previously, and that's pretty much the shape of it. Thank you again for your presence tonight, and please give a hand to our very gracious candidates who are here tonight with us. All right. I'm scrolling up to the top of my thing. So I'm going to ask each of you, and let's just, I'm going to start and go left to right, and go right to left. I'm just alternate back and forth. So I'm going to start with you, Judge Fennessy. Could you, for our audience, just summarize what is the job of a Superior Court judge? What do you do every day?
Thank you. First of all, I'll admit that this is a little intimidating to be invited to a forum that calls itself Judging the Judges. And that was a great reminder for me about how people probably feel in the courtroom. They do feel a little intimidated. They feel like they are being judged. And that's a difficult setting. So that was a great reminder for me. As a Superior Court judge, I think you have to be a number of different things all at once. First of all, you have to be an experienced generalist. You have to know what it is that the law is intended to do. What is the civil society we've all bound ourselves to be involved in? And how does that impact this specific area of the law? So you have to remember how dramatically important the issues are before you to the people that are before you. You also have to then be a subject matter specialist. And in Spokane County, we have a number of different dockets. We have 13 different judges, and each of us has a docket that we have to follow. And when you're on a criminal case, when you're on a civil case, you have to become a subject matter specialist in that area, whether it's family law, criminal law, civil law. We have therapeutic courts as well. Then you have to be a student. You have to be someone who's very interested in what's going on in front of you. You have to understand what the law says in this area. You have to understand what the facts are that people are bringing to you for that decision. And you have to understand what the law is in that specific area. And then you have to be a teacher, a communicator, explaining the application of the law to the facts that you find as you find them, and the reasoning and rationale for your decision. And finally, I think you have to be a passionate administrator. You have to be someone who is involved in improving the law and involving people's access to the law. Because every day the court has to be concentrated on protecting individual rights, recognizing the collective interest that we have, and then protecting the Constitution and applying and following it.
Thank you so much. Mr. VanWinkle.
Yeah, well, as far as the job of a Superior Court judge goes, that's spot on. But there's a couple more things, so I'm not going to just add on to it. So Superior Court is the court of general jurisdiction in Washington. They have anywhere where there's not an assignment for a case already, it starts in Superior Court and goes to Superior Court. But it's also where the serious cases are. So it's not where the traffic tickets are. It's not where the misdemeanors are. It's not where small claims is. It's where the felonies are. It's where the serious crimes are, the serious cases. It's where the serious civil disputes are, and even evictions, mental health proceedings, civil commitments, dependencies, proceedings to take away people's children. All of these serious questions that have permanent and lifetime effects on people's lives are what go to Superior Court and Superior Court judges. And building on the administrator, Superior Court is a very large and very expensive county department. And so just like any county department, they've got employees, they've got personnel issues, they've got stakeholders that they need to meet with and talk to, and they're also, to some extent, legislators. Those judges get together, they pass local court rules, they pass local procedures, and those rules are binding on other judges and other lawyers in the court. And so it is not just the judicial branch, but also within the judicial branch, there are also executive and legislative functions that go along with that.
Thank you, Mr. VanWinkle. In deference to like more intimate setting that we have, I'm going to dispense with the podium situation. I'm going to scoot this back and I sit down so there's a bit more conversational. It has wheels and runs. Thank you so much. I'll grab a chair. All right, it's a little bit more like it. I also, two things, I'm gonna pass these around real quick in case people do want to write down questions and we can collect them after the prepared questions. And I am going to give sort of time suggestions, but again, in deference to a more intimate setting, there are more suggestions to sort of keep us moving along, but I do want the fullness of both your answers. So with that, we'll get to the next one. Mr. VanWinkle, the next question that we had was, when are residents of Spokane most likely to come before you if you were elected as a Superior Court judge? And could you include sort of an explanation of the kinds of decisions that you would be making and their effect on ordinary Spokane's lives? And I get over about 2 minutes.
Okay. So building on those types of cases that we see, the ordinary Spokaneite really isn't going to come in contact with Superior Court, because the ordinary Spokaneite, if they're going to have contact with the court, it's most likely going to be a municipal or district court on a traffic matter or a small claims case or maybe a misdemeanor. Criminal cases, sadly, a lot of what we see on the felonies are actually repeat customers. So the ordinary Spokaneite, a lot of times we're not going to see them in Superior Court on the criminal end. The ordinary person, they're going to come in and encounter us as a party on a family law case, on a divorce, maybe a truancy because their child isn't in school regularly, or maybe it's a dependency case where the state is alleging that they need help with their parenting abilities. Those are the cases where ordinary Spokaneans are going to encounter us the most. And when we have jury trials, sitting as jurors, when people come in as jurors or maybe as a witness on a case, that's really where ordinary people are going to see us day to day and see how the job is done. But as parties go, it's most likely going to be in a family law case, maybe a probate trying to close out mom and dad's house and properties and belongings after they pass away. That's where we really come in contact with the public day in and day out.
Thank you. Judge Fennessy?
I agree that people normally come to court to deal with something that's gone on difficult in their lives. But we do have some really great things that we get a chance to do as well. We get to have marriages. Today I got to swear in a new young lawyer, pass the bar. We get to do adoptions. So we get some things that are really wonderful in our community. But I think people normally come because they have some sort of problem that they need help with. They have to deal with some piece, and Mr. VanWinkle mentioned probates, guardianship. Some of those things just happen as a result of life. We also have personal injuries or property damage, family law matters, and or when you're an accused or a victim of a crime. And that's when you end up interfacing with the Superior Court. Right now, because part of the question was when they come in front of me, I'm on the chief criminal docket. And so I'm making decisions about trial setting, about whether or not there should be a continuance in a case. I'm making a decision when there's a motion in front of me to reset bail. I'm making sure that every accused understands their rights. So I have arraignment dockets. I have what we call a stay docket. So people who have competency issues, they are in front of me. And so those are all the issues that are on the chief criminal docket that I'm dealing with right now.
Thank you. The next question that we provided in advance deals as a bit of a shift. Because judicial races are nonpartisan and judges tend to be relatively insulated from the general public who don't see them every week at a city council meeting or see them out and about at the sorts of partisan events that a lot of candidates attend. So that also means that many voters struggle to vote for them or leave the judge portions of their ballot completely blank. So with that in mind, what I want to ask, starting with Judge Fennessy, is what advice would you give Spokane voters who want to vote in the judge races? They want to fill out their whole ballot from top to bottom, and they want to choose the correct candidate that aligns with their values.
Thank you, and I think that's a very difficult question because, as we all know, judges can't answer questions about matters that might be in front of them. So some of the digging that you're going to have to do has to do with other resources. Just recently, one of our local news stations did a piece on just exactly this, and they spoke with the president of the local Spokane County Bar Association. They spoke with a professor at Gonzaga, and I think that you would find that online in terms of a good resource. And several things that I would suggest. First of all, you have to decide what type of judge is it that you're talking about. Is it a trial court judge? Is it an appellate court judge? Is it a Supreme Court justice? And in this instance, it is a trial judge. So we're talking about someone that has that type of experience, someone that has been involved in trials throughout their career, someone who's tried cases to the bench, tried cases to the juries, and in this case, have they served as a judge? Have they tried jury cases? Have they done all of those things from both sides of the equation? One of the things that you have a chance to do in Spokane, because of the size of our community, and you're doing it right now, meet the judge. Have an opportunity to see them, hear them, shake their hand, talk to them, look in the eye. In judicial races, one of the tools is endorsements. Who is endorsing this particular candidate? Are there other judges that are endorsing that candidate? Are there lawyers that are endorsing that candidate? Who are the members of the community that are endorsing that particular candidate? what are the testimonials saying? What do they say about the experience of that individual with the judge or with the candidate? And then there are a number of judicial evaluation committees across the state and local. We have the Washington State Veterans Bar Association. We have the Joint Asian Judicial Evaluation Commission. We have the Lauren Miller Bar Association. We have Q Law. They've taken a hiatus, so they're not doing judicial evaluations right now. Latino Bar Association. So there's a wide variety. And our local bar association also did a poll, and that should be published and is available as well.
Thank you. And just as a point of education, the Lauren Miller Bar Association is essentially it's the black bar. It's in Washington for folks who are curious.
So as far as finding out about the candidates, really the best way is to be here at events like this, where you are hearing them live in person, hearing their views, hearing their opinions. And I think the best way to find out about the candidates is Judge Fennessy mentioned that guide that one of the news stations did recently, that's KXLY, and that's available. And they talked about all those things, but what's really missing is the candidates' own words. The candidates have been doing forums. This is our third forum. We've been interviewed repeatedly by the Spokesman Review and the Inlander. And that's where you go to see our own words and our own voices, what our opinions are, what our thoughts are. Because endorsements only go so far when everyone's endorsed by judges, when everyone's got good ratings from evaluation committees, when everyone has lawyers that are supporting them, community members supporting them, and elected officials supporting them. You have to ask yourself what differentiates them. And really it comes down to their own words and their own opinions and what they're going to do on the bench, what their goals are. Do they have goals? Are there things that need to be changed? And what are their thoughts on them? And so more than people's opinions, more than people's endorsements, more than people's ratings, it's the candidate's own voice that I think people should listen to when deciding who to vote for judge.
Thank you. This next question, Mr. VanWinkle, I'm going to come back to you, and I am going to let's try to keep it close to 2 minutes. But on that note, in your own words, can you tell us why you would be a good Superior Court judge? And specifically, can you speak to your own character, professional experience, and accomplishments that demonstrate that?
Well, so we skipped the introductions earlier, so I'll do a little bit of that with this question. So my background, I'm a former prosecutor where I tried everything from traffic tickets to homicide and everything in between. Argued cases to our state's appellate courts, including our state Supreme Court. Currently, I work in-house at the Washington State Court of Appeals as the senior staff attorney there. And the Court of Appeals is the court just above the Superior Court, below the Supreme Court. And there we review cases from all 20 Superior Courts east of the Cascades. Every Superior Court judge in central and eastern Washington, their decisions are reviewed by the judges I work for. And so there, I help our judges decide the hardest cases that come before Superior Courts all over central and eastern Washington in criminal, civil, family law, land use, everything that comes before a Superior Court judge. And the hardest of the hard ones are the ones that come to the Court of Appeals because those are the ones where there's no clear answer on the law, where the law is undecided and at the margins and at the edges. I have to help advise on what the law should be, where it should be going, what it is. And in addition to that, in 2021 until July of this year, I also served part-time as a pro tem court commissioner in our Spokane County Superior Court. And the court commissioner is an unelected judge, is what they're called, or an unelected judicial officer. They're appointed. They do many of the same functions as a judge, but they don't preside over jury trials. They preside over different dockets. And a pro tem is a substitute for the courtroom. So when your regular judicial officer is out sick or on vacation, a pro tem comes in, dons that black robe, and decides cases. And so as a pro tem, I presided over hundreds of cases, 24 bench trials where the parties had waived the right to a jury. And in addition to that, I'm a repeated published author on Washington law, a regular speaker at conventions and trainings for judges and lawyers. I've presented trainings to the Washington State Judicial Conference, the Washington Association of Prosecuting Attorneys, the Washington Office of Public Defense, the Washington State Attorney General's Office, many local and regional bar associations. So as far as the background, I have the court experience, I have the subject matter experience, and I've got the experience learning the road. But what really makes me qualified to be a judge is my demeanor and who I am. When you come to court, it is often the most traumatic time in your life, or forces you to recall the most traumatic time in your life. And it's stressful. And what you need up there is a judge who's not going to add to the stress because you're stressed out. The other side is stressed out. The lawyers are stressed out. And you need a judge who's going to bring the tone down and the temperature down and be calm and cool and collected and work with the people in the courtroom to help them get past their troubles and help them resolve the case. And ultimately, I think that is what I bring to the bench, my greatest quality. It's not the experience, it's not the knowledge, but it's the intangible, who you are as a person.
Thank you, Mr. VanWinkle. And he's right, I did skip over the introduction, so hopefully this question allows you to get that out as well. Here we go.
Thank you. I was born and raised in Libby, Montana, and I learned where I had my first jobs. I washed dishes there, fought fires for the Forest Service there. I worked in the woods there for several years, even between undergraduate and law school, and 1 year after I started law school. And then I came to Spokane, and I've been here since 1975 as a student, then as a young lawyer, then as a young businessman, father, and so Spokane has become and been my hometown, and many places for me. In terms of what a judge has to do, a judge has to do what the job calls for. And sometimes, as Mr. VanWinkle mentions, that's bring the temperature down. That's make sure that people in the courtroom feel heard and that they have the opportunity to present their side of the case and present their story, and that they have a chance to hear the decision and have that decision explained to them the best and the most calm way that it can be. Sometimes it's to be firm and to tell the lawyers that they haven't done the job that they needed to do, that they haven't brought the information that the court needs to make the decision. And sometimes it's to make that hard call, and to make that hard call right there on the fly. This is not an opportunity for dozens of notebooks to be submitted and months of argument to be provided in written form. This is a chance where the parties have come to you with a very difficult decision, because if it wasn't difficult, they would have found the answer on their own. They wouldn't be spending their own time in front of you. But sometimes when you make that call, you have to make it firmly and solidly, and it doesn't sit well. One side walks out a winner and one side walks out a loser. So a judge has to be what a judge needs to be in the moment. And sometimes it is that soft, calm, collected individual. And sometimes it's someone that has to make a hard call and make a hard decision. In terms of my character, I speak plainly and directly. I am also human, and I also try to always be kind when possible, and explain my responses very carefully. In terms of accomplishments, like I have mentioned before, I've practiced law for 33 years. As private practice, I was a super lawyer in Washington. From 2011 forward, I had a 10 rating for AVVO, and I currently am the elected presiding judge of Spokane County Superior Court. I've been on the bench for 8 years, serving in a wide variety of roles, and I count all of those among accomplishments. My professional experience, I have tried cases, litigated cases, I've argued cases in courts of appeal, in the Supreme Court of the state of Washington and the Supreme Court of the state of Idaho. I've been to the Pepperdine Strauss Institute mediation training. I've arbitrated cases. And like I say, I've been on the bench for 8 years, and I believe that that time on the bench has made me a good judge, and that's why I think I will be good attorney.
Thank you, Judge Fennessy. We're going to switch gears a little bit and ask about something a bit more specific. So I'm going to share this as much with the audience as anyone else. In June of 2020, in the wake of the murder of George Floyd, the Washington State Supreme Court wrote a letter to the legal and judicial community that said, I'm going to quote part of it, our institutions remain affected by vestiges of slavery. As judges, we must recognize the role that we have played in devaluing Black lives. As lawyers and members of the bar, we must recognize the harms that are caused when meritorious claims go unaddressed due to systemic inequities or lack of financial, personal, or systemic support. We must also recognize that this is not how a justice system must operate. Too often in the legal system, we feel bound by tradition and the way things have, quote, always been. We must remember that even the most venerable precedent must be struck down when it is incorrect and harmful. We go by the title of justice, and we reaffirm the deepest level of commitment to achieving justice by ending racism. We urge you to join us in these efforts. Now that was from the highest court in Washington State, the Washington State Supreme Court, which also has candidates on the ballot. But what I want to ask these gentlemen, Mr. VanWinkle and Judge Fennessy, is how have you responded to this call by your most senior colleagues on the bench? And how will you respond in the future if elected to Spokane Superior Court Position 11?
Thank you. And I remember the killing of George Floyd very sharply because it occurred on my birthday. And not for anything other than 5/25. That's the day that George Floyd was killed. And we had a number of names before George Floyd and have had a number of names after George Floyd. And I'm old enough to know that as a country, we've struggled with racism. We've struggled thinking that we got over a hump and realizing that we have so far to go. So in the law, we've had what we call GR 37 Batson challenges to jury selection. And that became a particular interest of mine, and I spoke on a couple of different panels with regard to GR 37 challenges. And I've spoken to our State Judges Association about whether or not all of this means that we should be getting rid of peremptory challenges, that in jury selection, the only challenges that would be necessary are for cause. Those that say that the juror that is before you cannot be fair, as opposed to peremptory challenges allowing a party to remove that juror for their own reason or for no reason whatsoever. And this, I think, is one of the pieces that we can recognize may be baked into the system, maybe one of those pieces of systemic racism that we need to get rid of. So what did we do? I can tell you that Spokane County, I and a group of our other judges wrote our own letter. And it's on our website. And it says, in part, that it is with candid honesty that we recognize the role that the courts have played in these injustices. We must be better about recognizing shortcomings in ourselves, in our systems, and in our leaders. It is only then that we can roll up our collective sleeves and begin the hard work of instituting and institutionalizing real change. So we have we've brought in some trainers and some people to help us recognize in our own systems. We also instituted our own protocol through which we attach to each one of our minutes for each one of our judges' meetings. And it's a matrix through which we pass all of our protocols and practices and policies, trying to make sure that they have been evaluated to what impacts they will have on Black, Indigenous, Asian, Hispanic, Latinx, and other BIPOC people of color. So we are trying to do all of those things and recognize and address racism and systemic difficulties. All of that has to also be said in context with not an excuse, but we then suffered a pandemic that has impacted all aspects of our lives. And so we recognize and must address racism. I think we have a great group of judges with a wide variety of diversity and diverse experience to do that moving forward.
Thank you. Mr. VanWinkle.
So in the wake of the murder of George Floyd and our Supreme Court's call on the courts, the court where I work at the Court of Appeals, we're not in the limelight very often. We don't get seen very often. But one of the things that we've changed internally is every case that gets decided, there is always internal documentation in consideration of the question of how will this decision, because these decisions have effects in other cases and future cases, but how will this decision affect historically marginalized communities, not just communities of color, but all peoples who are historically marginalized? And we consciously consider that, and sometimes the answer is, well, this case probably won't have any direct impact or indirect impact, and sometimes it is a very thoughtful, long consideration of what goes on. But it's not enough for a court to have policies saying that we're going to look at these things and think about these things. We also need to do the hard work of improving ourselves. And so one of the things that I've worked hard on for me has been getting to understand and be competent in these conversations, in these spaces. And so you go home onto my library, you've got everyone from Ibram Kendi to John McWhorter. And if you're not familiar with these two authors, they are two very current Black authors on social justice issues. And even though they both agree on the same goal, they could not be further apart. These two men do not get along on the answers to racism and the answers on these issues. But I think it's important for judges and anyone in leadership to be reading these authors, reading these thought leaders, the current thought leaders, especially when we don't come from these communities, to understand what's going on and to understand how is racism defined? What is racism? And understanding that racism isn't just personal animus, but it also goes to the structures and institutions. And beyond that, I think it's also incumbent on judges as being leaders in our communities, not just to have these policies, but also, as our Supreme Court has done, come out and use that bully pulpit collectively to talk about these issues. And that, I think, is what we've really been missing here in Spokane. And one of the things that's really disappointed me, in 2021, our Law and Justice Administrator, Maggie Yates, went before Rotary, downtown Rotary 21, to have a presentation about racism in our courts here in Spokane. And she got shut down. Spokesman covered it, the editor covered it, anyone who's interested in that can go read about it. But what I didn't see in the wake of all that was anyone coming forward in a position of power to say, Maggie, you're right. Racism does exist in our courts. It does exist in our community. Racism exists here in Spokane. And I think our judges missed an opportunity there to exercise that bully pulpit, to vindicate the experiences of communities of color in Spokane when they are being gaslit and told, no, it's not a problem here, it's just a problem in the South. And I can tell you, racism exists in Spokane. Racism exists in our courts. It exists sometimes in places where we wouldn't think that it exists. And I can tell you from personal experience presiding over cases in Spokane County Superior Court, I have had lawyers make racist arguments to me. And I don't think it was racist in the sense of personal animus. I think it's racist in the sense that Ibram Kendi defines racism. It's a broader definition of racism. And I don't think they understood that the arguments that they were making were racist and that the decision they wanted me to make would have a disproportionate negative impact on people of color. But it wouldn't. And I think that's what we're missing, is we are missing opportunities locally to say, yes, here, not just in the South, not just in other places. And I think that's what our Supreme Court has really called on us to do, is to validate what's going on in our community and reaffirmed from a position of power, because judges are people who can't just be ignored and explained away as weird people on the streets. They're elected.
Thank you. I think we have one question left for both of you before we get to things that people may have written down on cards. I'm going to volunteer my friend here to collect people's questions on cards. If you have a question, you want to ask a question still and you haven't written it down, please still do, and then just pull it up and we'll get it from you. But if people don't think so, I want to get them down. For our last of the questions, the advanced questions, on a similar note, the criminal legal system, as both of you noted, can be extraordinarily intimidating for people. People with cultural and language barriers are often at a particular disadvantage. So, as a judge, how do you, or how will you, respond to differing levels of comfort with this system between parties in your court and the various people who come before you? I'm going to start with you, Mr. VanWinkle.
So when I was working as a prosecutor, it was over in Chelan County. Chelan County, for people who don't know, is a county with a large Hispanic minority population. These schools are actually majority minority, and Chelan County, by the end of this decade, is projected to be one of the first majority minority counties in the state. And so working in a county where the people who come to court are not just white, but also people who are recent immigrants to this country. We had 3 Spanish court interpreters on staff because the need was that great. So almost every day for every year that I was there as a prosecutor, I was in court in hearings where we had to do interpretation, work with people from different communities, not from the US, not born and raised in the US, who have different cultural norms and cultural values, and try to understand them. And I think with that experience, I'm able to understand and work with our minority populations in Spokane in a way that I would not have had I not had that experience working almost every day with immigrant populations, not just minority populations, but immigrant populations in Spokane. When I've been on the bench, I've had to have Russian interpreters, Arabic interpreters, Spanish interpreters, because we do have very different immigrant populations here in Spokane. And these people, overwhelmingly, they're overwhelmed to come to court because not only do they have the language barrier, but it's also in court where people have basically the highest linguistic skills when it comes to English. And it's very intimidating, it's very foreign. And so things that we can do, one of the things that our judges in Chelan County did was that they made sure that all the signage in the courthouse, throughout the courthouse, and guides were bilingual. Other counties in the state have done that. I know Spokane's done that to some extent. They're working on it, but I know that there's still more to do. It's a big courthouse. It'll take a while to get there, but that's one of those areas where we could make the court less stressful for people, more inviting for people, is to have signage in their native language, just to take out one more stressor. But also in court, when you get into court, having a judge who is that calm, cool, and collected person who's going to take the time that they need and to take the time that other people need to speak and talk, especially if the English is not their first language. Some people will try and go without the help of an interpreter, and sometimes you need a judge who says, it's okay, we can get you one. They're embarrassed to ask, they don't know that they can ask, or they're afraid that they're going to have to pay for it. So also having judges who let people know what their options are when they're not familiar with court, let them know that they can ask for accommodations and they'll have accommodations. I think those are all important things that we can do to help people who are not comfortable in the court setting, who aren't native users of the court setting like lawyers are.
Thank you. Judge Fenessey?
I think I come to this issue with a little bit of lived experience, in that I married a woman from Iran, and both of her parents came in fleeing the revolution midlife. My father-in-law was 50 plus years old and a very accomplished geologic engineer in his home country, and he wasn't allowed to have a professional license in America. nobody wanted to have to hire him. And my mother-in-law had never had to work a day in her life. And she went back to school and became one of the primary breadwinners is when they opened their own business making bread. And so I come to that, and that when I met them, their English was good, but it wasn't perfect. And they dealt with language barriers in negotiating contracts and trying to understand what was going on legally. And even in accomplishing things about zoning, things that they needed to do with property that they bought. Because in their country, the cultural norms were different. In their country, you knew the right person, you paid that person, and that your goal was achieved. And here their son-in-law was a lawyer, and he didn't know who to pay. So I do come at this with a little bit of an understanding. When my father-in-law got his jury summons, he was scared to death to come to the courthouse and to participate in that process. So I understand it from a language barrier. I understand it from a collateral, a cultural lens. And I recognize that many people have implicit biases thinking that people who don't speak perfect English don't understand. And that is something that we have to rid ourselves. So we have to recognize that many things get lost in translation, as Mr. VanWinkle mentioned. Many times people strive to say that, yes, I understand, when they don't, because the words that we are using are not broken down. So that's one of the things that we as lawyers needed to do in explaining a case to a jury. And it's something that we as judges need to be very conscious of, is shrinking the words, make it at an easier to understand level. And we have to do that repeatedly. When we can, we have to take the time to make sure that they understand. And there are dockets when you can do that easily. There are dockets when it's very difficult. And in those circumstances, you need to make sure that you know who got the interpreter, you know that the interpreter actually speaks this particular defendant or witness's dialect, and then they're ready to go and have done that work on their behalf. We do have signage that is universal throughout our courthouse. We are continuing to work with our district court and our municipal court to make sure that that signage is more and more and more complete. We have just recently retained a service so that our forms, the paperwork can be translated from native tongue to English and back again, so that people that are there for family law cases and they write in Spanish, they can write their supporting documentation with regard to a no contact order or their divorce filing in Spanish. We send it out and then get it back interpreted, and so we are addressing all of those things. We do need to get better. We need to keep getting better. And the one thing that the court doesn't have is the power of the purse. So it's a part of making sure that we advocate to the Board of County Commissioners, that we advocate to the Administrative Office of the courts, that we advocate to get the funding necessary to provide the services that we know we need.
Thank you. And thanks to both of you, Mr. VanWinkle and Judge Fennessy, for taking the time to answer those questions and giving us really thoughtful responses. I'm going to now grab the questions that came from the audience. I'm also going to give us 30 seconds to stand up if we need to and stretch and whatnot. Before we get into these, check in and see if we have any questions online, and I'll be reiterating the guidelines for questions in case someone thinks up something. So get us in. All right, do we have any questions in the Zoom at all? All right, looks like it's just us here for now. I'm going to warn y'all that at least a couple of these I might struggle to read because my reading is only as good as your handwriting. Just to reiterate the guidelines, I'm going to pull these up again. All right. So I'm going to start with these written questions I just dropped on the board right here. Once we get through them, people, you can raise your hand and wait to be recognized or submit in writing questions so that you want to ask, and we'll give the mic to you. Once we do that, if I give you the mic, please speak into the mic. I'm sure you can project. I'm sure you have a great theater background. I'm sure your voice is as deep and lovely as James Earl Jones. Please speak into the mic regardless. Along with that, we ask again that you keep your questions as concise as possible and respectful as possible. Again, our goal here is first and foremost education and learning. And finally, please limit your questions to issues that relate to the job of a Spokane Superior Court judge and issues of Spokane County. Now that the candidates have answered some of these standard questions and talked about their job, hopefully we all better understand what this means. Questions about laws passed by the legislature or issues exclusively within the jurisdiction of other courts, such as the Supreme Court of the United States, will be excluded, and I will direct our guests not to answer. So thank you again. Also, when you're done, please give the mic back. And with that, I'm going to start reading some of your questions. So the first one, and I will start with you to my left, Judge Fennessy, is one person asks, how does racism specifically enter the courtroom, and what can you do as a judge to mitigate racism?
One of the ways that racism enters the courtroom is we don't have a choice in the criminal setting. I'll speak about that first. Who comes before us? There's discretion and or bias, racism that is exerted or is possible, let's say, at so many levels before they ever enter the courtroom. And one of the ways that we know that that happens historically is areas of policing. And many times it's talked about in lots of literature, and I'm sure that it's true in Spokane County, that there are areas that are known as high crime areas. There are areas that are known as undesirable areas, and those areas get more attention from our police force, and they may very well be back in the day occupied by Italian or Irish immigrants, and today they may very well be home to our Black population. They may be very well homes of other individuals. Those places get over-policed, and as a result, the residents and the people that live in that area are involved in our justice system, and that then could be elevated by the next level of discretion with the charging decisions that is made or are made by the prosecuting attorney's office. So those are two ways clearly that racism can be inserted and come before the judge ever gets an opportunity. What we can do as judges is to make sure that we are paying attention, to make sure that we understand, and when we have sentencing questions, that we understand that we can take the time and ask the question of the prosecuting attorney, is this the same recommendation that you would be making for a white defendant? Is this the same sentencing decision that you would be asking me to make within some other setting? So racism is baked into the system, and we can all talk about that. Our system goes way back to the days when only landowners were involved, when only men could be involved in the vote, or it could be, so our system was created with those purposes in mind. Those purposes result in racism, and that racism has not been sought out at all levels. So we have to continue to keep our eyes and ears open. In Spokane County, we've just only recently been able to root out some of the zoning ordinances that were passed and that bake racism into neighborhoods. And those things still come before the court. Our Supreme Court, our courts of appeal, can sometimes reach back, as our Supreme Court did, and find an older case that has those racist overtones and can address them. That's not something that the trial court can do.
Thank you.
Thank you.
Mr. VanWinkle?
So racism enters our courts from every corner. It's not just from law enforcement. It's not just on the criminal end. It's from everywhere. And that's one of the things that we have been trying, and what our Supreme Court has been trying to educate people on, is that racism is not just individual animus. It has many different stories, many different faces, many different ideas. And it goes all the way to our state constitution, which was drafted in part by a researching KKK in 1889. Many people don't realize that the KKK, after losing the Civil War, some of them came over here. In Seattle, near the UW, there's a Daughters of the Confederacy monument. I think it was taken down a couple of years ago after the wake of George Floyd's murder. And we have provisions in our state constitution that were intentionally put in to keep communities of color down. And when I say communities of color, it's not just people of brown skin, it's people of olive skin too, because back then, as Judge Fennessy alluded to, people of Italian descent weren't considered white, and they were considered brown, and they were discriminated against. And so in our state constitution, some of our educational provisions were actually drafted by the KKK for that purpose. So it's in our laws, and it comes all the way down in our laws. That laws are influenced by that when they're written, but also it's in our judges. Myself, one of the things that I've had to come to terms with and understand, and that's why you read authors of color and you read thought leaders in this area, is you understand I don't just choose one day to be an anti-racist and then I'm an anti-racist for the rest of my life. No. Sometimes I'm a racist. Sometimes I do racist things. Sometimes I do non-racist things, who Dr. King would call the moderate white. And sometimes I'm an anti-racist. And it's not just you or this all the time. Everyone, even Ibram Kendi and others, they acknowledge that they have their racist moments where they discriminate against people of color, and they catch themselves and they go, oh, that was me being part of the problem, not part of the solution. So we need to understand that as judges, as best intentioned as we are part of the problem sometimes, and we need to be open to that feedback, and we do need to have open channels of communication to the communities of color in Spokane so that they can, in a safe way, provide feedback to us when judges make poor decisions or make ignorant decisions, or when lawyers make poor arguments or biased arguments or ignorant arguments. And jurors as well, we try and root that out in jury selection. We try to root out people's biases in jury selection because biased jurors come in. We try to police the lawyers and their biases, as Judge Fennessy mentioned, the General Rule 37 that our Supreme Court enacted a few years ago. And it comes in witnesses. It comes in through every door of the courthouse and every person in the courthouse, including the judges, including myself. And all of us need to be aware of that and on guard about it.
Thank you. I'm going to do a little insert question here. Both of you referenced General Rule 37. And for folks who aren't familiar, could you nutshell that for us? And I'll give each of you give us 3 sentences.
So General Rule 37, our Supreme Court recognized several years ago that the U.S. Supreme Court case Batson versus Kentucky, which was a monumental case that said it is unconstitutional to get rid of a prospective juror based upon the color of their skin. That if you want to get rid of black jurors because you think black jurors are going to acquit this defendant, you can't do that. Our state Supreme Court looked at studies over the decades and anecdotal evidence over the decades and said, you know what, Batson hasn't worked out the way we thought it would. We need a little bit of a stronger antidote here, a stronger remedy. And so our Supreme Court took the next step of creating its own version of Batson, which we call General Rule 37, that says the excuses that lawyers historically used to give to get around Batson are presumptively not going to be good. And if you want to strike a person for a reason that's historically been associated with striking out people of color, you need to give a good reason. It needs to be documented. It needs to be supported by the record. In a nutshell, that's General Rule 37.
Thank you. Anything you want to add to that?
General Rule 37 says that if a reasonably prudent person could look at a strike and believe that it was based on racial animus or some other protected class, that whether it's institutional ableism, whether it's because you don't want someone on that jury who XYZ, that is an improper challenge. And the court has to pay attention and watch for those. And when a challenge is made, the court now has a duty to excuse the jury and then make sure that the lawyers put it in the record, their rationale for the strike, and challenge that. Could a reasonably prudent person watching and listening to that strike believe that it was exercised because of some protected classification? Then it's an improper strike.
Thank you. And just to clarify, when we talk about strikes and challenges, we're talking about the process by which lawyers are saying, hey, you don't get to be on this jury, thanks, you're excused, correct?
Correct. Thank you.
Thank you so much. I feel like this rolls really nicely into another question that was submitted. As human beings, this person asked, we are all flawed and have biases towards different groups of people. But the biases of judges could have severe impact on individuals' lives. What would you do to counter your, and this is the word, that potential, there we go. What would you do to counter your potential biases in your decisions? I'm not sure whose turn it is. I think it's yours.
I think it.
All right.
Well, obviously, as Mr. VanWinkle mentions, you read, you stay educated, you attend trainings, you speak with other judges, you check yourself, you reach out and ask other judges for input, you reach out and ask other communities or other community members for input. The question is spot on. We all have implicit bias. We all have things that we don't even know we're biased about. And so all we can do is all we can do. And we have to do it each and every day. We have to make sure that we're staying educated, that we're staying interested, that we're staying activated to recognize this shortcoming in ourselves and to try to make sure that it doesn't impact the decision and that the decision that we make follows the law.
Thank you, Judge Fennessy. Mr. Winkle.
Right, so acknowledging that we've got these biases, you don't necessarily know that they're there. And the way that you handle them at the Court of Appeals, we gave one way that we do is we try to actively think about how our decisions can affect people. We try and look in our blind spots, turn our head and check who's driving behind us. We try to do that, but that's not always going to get your biases. And in the trial court, the best way to check your biases is to get feedback from people who are there and watching you. So when I was in Chelan County, as I mentioned, we had court interpreters on staff, people who were from different backgrounds. And if you have good relationships with them, they'll tell you when you're doing something stupid. They'll tell you when you're being biased. They'll tell you when you're maybe not looking in your blind spot. And that was one of the things that I cherished most about working there in a small community, in a small county, and having good relationships with all the staff, is they could say, you know, Andrew, maybe you should look at this case this way. Have you thought about this? Or, Andrew, Do you know anything about this part of Mexico where this gentleman's from? No. Let me tell you a little bit about his home state where he grew up. You need people who you have those open lines of communication with, but also who you can talk to without getting defensive with and say, yes, I need help. Yes, I need to know about this. And one of the things that I love about SCAR is their court watch program, that they have people who come and watch hearings. And I think we need more of that, but I think we also need open channels of communication where judges can get that feedback. So if people do have concerns about judges missing biases or lawyers who have biases that aren't being addressed, maybe someone in court watch thinks that a judge didn't handle a lawyer the right way. We need ways to get that information back to judges, but to do so within the confines of the judicial ethics that we're under and within the confines of not creating conflicts with case and not violating rules against one-sided communication. And I think we can do that, but that's the best way, is to have people who see you and watch you give you that honest feedback.
Thank you, Mr. VanWinkle. You honestly couldn't have set up the next question better, because my next question, and so you can expound more on this if you'd like, is what advantages or disadvantages might court watch or does court watch bring to your courtroom?
Well, on one end of it, judges and lawyers don't necessarily like to admit it, but when there's someone in the courtroom who they don't know and they don't know why they're there, they get a little nervous sometimes. And as a result, oftentimes, they're on their best behavior. It shouldn't be that way. Judges and lawyers should be on their best behavior, whether or not someone else is in the courtroom or not. But it's true. When there's a stranger in the courtroom and you don't know why they're there and you know that they're not attached to the case somehow, they're on better behavior. And so that's good. Just having someone from court watch in the courtroom by itself is good. But the next step, I really think, is some sort of ombuds program where you designate a judge who's not involved in the case, who could be the clearinghouse for concerns. And that judge can maybe take some time out, meet with court watch, meet with people, document the concerns, because sometimes the judge who was there, it's going to be years before the case is going to be resolved. And those memories aren't going to be fresh years later. But if a different judge who's not involved can work around those ethics issues and document the concerns in real time, and then circle around and come back to it when they're able to within the bounds of ethics, I think that would bring court watch to the next level.
Thank you. Judge Fennessy, what advantages or disadvantages might or has court watch brought to your courtroom?
I can't say that I change my behavior when I don't know people in the courtroom, because right now, on the docket that I'm on, I don't know who's in the courtroom. Sometimes it's an undercover police officer. Sometimes it's other family members. So I really don't think that seeing someone in my courtroom that I don't recognize modifies my behavior. But certainly having a court watch program is an advantage to the court. We know that the program has been initiated. We understand that there will be people that are going to be speaking to others if they see something in the courtroom, and that's a huge advantage. That's what we want as judicial officers. I agree with Mr. VanWinkle that the next step in making sure that the communication can be shared with the judge that was observed, that would be a wonderful next step. And I would look forward to anybody and everybody being able to share those communications. In Spokane County, we all have cameras in our courtroom. In Spokane County, most of the time now, we have Zoom channels that are up in our courtrooms. And so we know that we need to be on our best behavior, but it really isn't best behavior. It's just do it and do it again and do it again and do it again. Not forgetting, do it better, which we need to learn from. And so when we get the opportunity to learn, we welcome it, I think.
Thank you, Judge Fennessy. That brings me to the last of the written questions. I just want to give a chance for anyone in the room, if you think you might have a question that you want to ask, to stand up or raise your hand as our guests answer this final. question we have here written down, and just to check to see if we've got anybody online who has any questions. All right, well, that's being checked. Let's ask, and I believe I'm starting with you, Judge Fennessy. Can you see restorative practices in our criminal legal system, and in what circumstances might you employ such practice?
Well, restorative justice and restorative practices need to be cooperative and corroborative. So we certainly have room for such practices, and we, I think, are working to develop such communication and relations in many circumstances, ways to help victims of crime meet with perpetrators of crime and formerly incarcerated individuals. So breaking that down and bringing it down to individual specific cases in our courtroom, I think that we would be very appreciative of that. And I think that the difficulty or the problem that it poses is how do we make sure that we're ensuring the safety of each side of the process. And when we have restorative justice programs that are taken outside of the courtroom, what purpose and how do we insert the judge in that process or the court back into that process? Because we do have a lot of restorative programs that are taking place in family law cases that are outside of the court's prerogative and outside of the court's parameters. But our therapeutic program, I think, has a real component, so that if we can have those accused or those offenders going through the therapies, going through the training, and making reports, and then we can involve their families in those processes and help restore that, as we do with reunification in family law cases. Those are all areas that I believe that restorative programs benefit, and continuing to grow those will benefit. One of the complications and difficulties is making sure that we have the resources, because we are presently, as a justice system, under-resourced and underfunded. And having these programs is wonderful, would be wonderful. We need to make sure that we find the appropriate funding, and there are things that I think, unfortunately, probably come first when it comes to funding in some other areas.
Thank you. Mr. VanWinkle?
For the restorative program, Spokane has a lot. We have a lot of different therapeutic courts and treatment courts in our Superior Court, but also in our district and municipal court. It's wonderful to see that, because a lot of communities don't have that. And one of the frustrations that Judge Fennessy mentioned is the funding, because these programs are voluntary programs. They're not mandated. We implement restorative justice programs on the juvenile end all the time, and those are legislatively mandated, and there are resources for that. But the voluntary programs, that's where we've got room to expand. Just over half the counties in the state now have a family treatment court, which is drug court for juvenile dependencies. We've got a little bit of that with our Safe Baby Court and juvenile dependencies, but there's more room to expand and grow. And some areas where there's room for restorative pathways will require legislative change as well. We've got a family law system right now where the statutes are really set up to encourage conflict and not to encourage resolution and restorative pathways. And with some legislative changes, I think we could bring some restorative justice principles to divorce proceedings and child custody proceedings in a way that we don't see it right now. But those ultimately are policy questions that judges can't put in place on their own, but judges can, through the Superior Court Judges Association and their lobbying, speak out on issues related to the administration of justice and the needs of the courts, and be out there and outspoken about the needs for more restorative justice principles. But of course, authorizing more voluntary programs doesn't help if we don't put the money behind it. So that is unfortunately a big logjam for us here in Spokane and many communities for expanding therapeutic programs and restorative programs.
Thank you. I'm going to call them an audible here and move to just hear kind of some final words from you both. Just what you would like to say about yourself, and final information that you would like to leave Spokane voters with. I'm gonna check my little notes to make sure that I asked this last question correctly. Essentially, oh, there we go. This is essentially a moment for you to share anything that you feel is very important to you to be shared with our audience, with anyone watching this that you haven't got a chance to say yet about law or about yourself. I'll ask you to give about 3 minutes. And after that, we'll end the stream and just informally discuss here, those of you who joined us. Thanks again for that. For sort of that final wrap up about yourself, starting with you, Mr. VanWinkle.
Well, I appreciate, again, Jack and Star for hosting this forum and having us talk about these issues, because these are issues that unfortunately don't get a lot of attention in Spokane and don't get spoken about, at least not in a public setting and not in a setting where you've got judges and judicial candidates speaking about it. And I think it's important to have both of us out here, Judge Fennessy and myself, validating and confirming that these issues are issues in Spokane and they are being worked on and they do need to be worked on and there does need to be more. And so I guess what I'd like to close with is a callback to Dr. King. So in 1963, sitting in the Birmingham jail, he wrote this famous letter from the Birmingham jail. And as an 18-year-old in college, reading that for the first time, I didn't really understand it. But as I've gone back to it over the years, it resonates more and more. And one of the things that he did was call out his frustration with the white clergy. And he called out the white clergy who he thought was going to be on his side and help him. Instead, he called them out for sitting in silence behind their, how did he phrase it? It was anesthetic stained glass windows that let them just hide in their churches and not take a position and not speak out on these issues and just say what's going on out there is out there and what's in my church is okay and everything's fine. And here in the 21st century, it's our judges who are hiding behind the anesthetic stained glass windows. That's what our state Supreme Court called on us to do in 2020, is get out there, use that pulpit, go to community events like this, talk to communities of color, be seen at Pride, be seen at Juneteenth, be seen at these events and confirm what people are saying and seeing and not repeat mistakes of the past.
Thank you. Judge Fennessy.
I too want to say thank you very much for allowing us this opportunity and sharing this stage. I don't see the trial bench as a bully pulpit. And I don't see Juneteenth or Pride or some of those committees or community events a place to be seen. I think we have to belong to this community. And I think that that's what the bench has to do. And I think in order to reflect our community, we need to have diverse judges. We need to have, and we are doing that. If we look at our Washington State Supreme Court, if we look at our courts of appeal, if we look at our Superior Court, we have 200 judges in the Superior Court. More than 50% of them have been selected or elected, appointed or elected since 2019. And though the diversity that is exhibited in those appointments and those elections speaks volumes. And we have to continue to speak those volumes. We have to continue to be involved. Spokane County has been involved in the Color of Justice, a program where we invite young people of color to come to the courthouse and spend a day with us and spend a day with our judges and to learn about the system. We need to continue to take those steps and to recognize that sometimes, and I think this is one of those times, we need to make sure that we have the experience so that we don't lose what's good about our system and in trying to scramble after change. And we absolutely have recognized and need to continue to recognize our implicit biases, continue to recognize the things that are baked into the system, and make sure that we are making progress that brings the good along as we bring along this change. So again, I thank you. We do have a certain structure in the court system. I believe that I have the information and the knowledge of that structure. I believe that I also have the desire to recognize change and make change where it's necessary. And so for that, I would ask for your support as well. Thank you.
Thank you. Let's give our best a hand. All right. With that, I'm going to ask that we end the stream for now. Goodbye to everyone who joined us online or is watching on Facebook or wherever. Thanks for that. And at this point, since we're done with this bit, I don't want to monopolize our guests' time. However, you have a few minutes to chat, whatever, as people are heading out. We've got the space for about 20 more minutes, and then we got to be headed out. Thank you so much for being here, all of y'all, despite missing the governor's debate and other things. Really appreciate it. And yeah, that's it, y'all.
Thank you.
Thank you so much.